Hello, everyone, and welcome to Thursdays Live with Chug. Each week, we cover pressing topics that matter to you and your business. I'm Arianna Gonzalez from Chug Attorneys and CPAs, tuning in from our San Diego office. And please join me today in welcoming two of our wonderful accountants, Maunika and Jaykumar Patel, from our Atlanta, Georgia office. Hi there, Maunika and Jay, and welcome.
Hello, everyone.
Thank you so much for being here. Today's topic is unveiling the power of beneficial ownership information with FinCEN. Just a quick disclaimer before we get started. We are live on YouTube, LinkedIn, and Facebook. This conversation is for informational purposes only. It does not create an accountant-client relationship. So please, if you have questions, email us at info@chug.com so we can help you out. On to you, Jay.
Thank you, Arianna. Hello, everyone. This is Jaykumar Patel from Chug CPA Atlanta. Today, I am going to cover the highly anticipated topic of FinCEN by beneficial ownership information. So, the introduction to the Corporate Transparency Act. In 2019, the Congress passed this bill that addresses and discloses the corporate ownership and prevention of money laundering and the financing of terrorism. The Corporate Transparency Act, that is CTA, was enacted by US Congress on January 1st, 2021 as a part of the National Defense Authorization Act. The CTA includes significant reforms to anti-money laundering laws and is intended to help and prevent and combat money laundering, terrorist financing, corruption, and tax frauds. The CTA establishes a beneficial ownership reporting requirement for corporations, LLC, and other similar entities formed or registered to do the business in the United States. The beneficial ownership reports must be filed with the FinCEN, that is Financial Crimes Enforcement Network. The CTA also imposes a civil penalty and authorizes the criminal penalties such as a fine, imprisonment for the term up to the 3 years, or both for providing the false or fraudulent beneficial ownership information or for willful failing to provide the complete or updated beneficial ownership information.
So let me introduce what is the FinCEN. FinCEN is a bureau of the US Department of the Treasury. FinCEN mission is to safeguard the financial system from illicit use and combat money laundering and promote national security through the collection, analysis, and dissemination of the financial intelligence and strategic use of financial authorities. FinCEN exchange financial information with foreign intelligence unit counterparts around the world in support of United States and foreign financial crime investigation. The basic concept underlying FinCEN's core activity is follow the money. Congress has given FinCEN certain duties and responsibilities for the central collection, analysis, and dissemination of the data reported under FinCEN's regulation and other related data in support of government and financial industry partners at the federal, state, local, and international level.
Annually, more than 1.8 million corporations and limited liability companies are being formed in the United States without having to disclose the beneficial ownership data to the states of incorporation or formation or registration authority. Now, with the introduction of beneficial ownership reporting, FinCEN will be receiving the information about ultimate ownership and ownership of the entities formed in the United States and specified foreign entities. In contrast to the US, all 28 countries in the European Union are required to maintain the corporate registries that to include the ultimate beneficial owner of the companies organized in the jurisdiction that comprise the European Union. On September 30th, 2022, FinCEN published a highly anticipated rule that implements the ultimate beneficial ownership information reporting requirements of the CAT. Beginning of January 1st, 2024, many companies in United States has to report information about their beneficial owners, that is, individuals who ultimately own or control the company. They will have to report the information to the FinCEN.
So, reporting companies under the BOI reporting means companies required to report are called reporting companies. Reporting companies have to obtain information from their owners and report the information to FinCEN. So, what are reporting company includes? A corporation, a limited liability company, or other entity that is created in the United States by filing a document with Secretary of State or any similar office under the law of state or Indian tribe, or a foreign company that was registered to business in any United States or Indian tribe by such filing. FinCEN has set fourth 23 exemption for entities that are not considered reporting companies under the CTA. The ground for the exemption is many of these are entities that are either closely regulated or already required to report their beneficial owners. Other entity means limited liability partnership, LLP, business trust if registered by filing with SOS, single member LLC or trust if formed with Secretary of State.
As mentioned by the Maunika, there are 23 entities that don't have to file the BOI information with the FinCEN. That includes first, security reporting issuer, second, government authorities, third, banks, fourth, credit union, fifth, depository institution holding the company, sixth, money services business holding company, seventh, broker or dealers in securities, eight, security exchange or clearing agencies, nine, other exchange act registered entity, 10th, investment company or investment advisors, 11th, venture capital fund advisor, 12th, insurance companies, 13th, state licensed insurance provider, 14th, Commodity Exchange Act registered entities, 15th, accounting firm, 16th, public utility companies, 17th, financial market utility companies, 18th, pooled investment vehicle companies, 19th, tax exempt entity, 20th, entity assisting a tax exempt entity, 21st is a large operating companies, 22nd, subsidiary of certain exempt entities, and 23rd, inactive companies.
So let's say an example of some exemption entities. So main is the large operating company. So what does it mean? More than 20 full-time employees in the United States, an operating presence at a physical office in the United States, and filed the previous year federal income tax return in the United States demonstrating more than 5 million in gross receipt or sales, including income or sales by owned by such entity and through which such entity operates. Those are called large operating company. Inactive entities means was in existence on or before January 1st, 2020, is not engaged in active business, is not owned by a foreign person, whether directly or indirectly, wholly or partially, has not experienced any change in ownership in last 12 months, has not signed or received any funds in excess of $1,000 in last 12 months, does not otherwise hold any kind or type of asset whether in US or abroad, including ownership interest in any corporation, LLC or similar entity.
So now first we have to identify that the company is reporting company or not. So if the company is under the exempt list, that is not under the reporting requirements, so they are not the reporting company. So those who are the reporting companies, we have to identify who are the beneficial owners. A beneficial owner is any individual who directly or indirectly owns or control at least 25% of ownership interest of a reporting company, or who has the exercise substantial control over the reporting company. So if you are not owing more than 25% of the ownership interest, but still if you are having the control over the reporting company's decision making, then also you are the beneficial owner. An individual might be a beneficial owner by the virtue of their substantial control, ownership interest, or both. The ownership interest, the reporting companies are required to identify all the individuals who own or control at least 25% of the ownership interest of the company. The ownership interest includes equity stocks or voting rights, a capital or profit interest, convertible instruments, options or privileges, and any other instruments, contracts, or other mechanism used to establish ownership. Exceptional to the beneficial owners, a minor child is exceptional, a nominee for the company exceptional, the intermediary exceptional, custodians exceptional, or agent for the beneficial owner are also exempt or exceptional, and employee or inheritor or creditors all are exceptional to this rule.
So, what is beneficial owner with substantial control? Reporting companies are required to identify all individuals who exercise substantial control over the company. An individual exercise substantial control over a reporting company if the individual meets any of four general criteria, which are: the individual is a senior officer, or the individual has authority to appoint or remove certain officer or majority of directors of the reporting company, or the individual is an important decision maker, or the individual has any other form of substantial control over the reporting company.
Along with the beneficial owners, reporting company has to report the company applicants also. So company applicants are the individuals who directly filed the documents that created or first registered a domestic or foreign reporting entities. The individual who was primarily responsible for directing or controlling the filing of the first or creation of the registration document. If the reporting company created or registered on or after January 1st, 2024, then reporting company has to file the information about the company applicants. If reporting company created or registered before January 1st, 2024, then not required to report company applicants. If there are attorney who applied for creation or registering the company, the name of the attorney should be entered as a company applicants. So here the company applicants are all who have under their capacity have applied or created this company for the first time, and their information has to be reported under the FinCEN.
So, what are the information needs to be reported? Reporting company needs to report a full legal name, alternate name, that means trade name or DBA name, jurisdiction of formation or first registration, full current US address, tax identification number details, including any foreign tax ID if not having US, the individual who was primarily responsible for directing or controlling the filling of the creation or first registration document.
Secondary, the company applicant information that we need to report. Under that, we need to report the company applicant's first name, last name, middle name is there, but it's optional. Date of birth of the company applicant, current full address, whether it is a business address or a residential address, that has to be reported. again, the identification of their individual has to be there. So on the identification, it's provided that state driving license or state ID or US passport or foreign passport is required. And all this identification type has to be attached in PDF form to the FinCEN.
So what are the information needs to be reported to beneficial owner? Individual first name, last name, individual middle name, that is optional, individual's date of birth, full current residential address, form of identification and issuing jurisdiction, ID number and issuing jurisdiction of either one out of below documents, which are state issued driver license or state local ID or US passport or foreign passport. All any identification needs to be attached PDF document of above selected identification type.
When and how to report. FinCEN has already started the submission from January 1st, 2024 through the fincen.gov/BOI. If the reporting entity was created or registered prior to January 1st, 2024, the deadline to report is January 1st, 2025. So for the entities who have been registered before January 2024, for them, it's a 1 year time is available to file this form. If the reporting entity was created or registered on or after January 1st, 2024, deadline to report is 90 calendar days from the first SOS registration date. So first SOS registration date, that is the registration with the state, is required to identify the due date of filing this form. If the reporting entity was created or registered on or after January 1st, 2025, then they have only 30 days, 30 calendar days to file this form from the first SOS registration date. Any updates or correction to the BOI once you have initially filed this form, you have 30 days to report or any kind of change or updates once the updates made or initial filing done.
So next is FinCEN Identifier. FinCEN will be required to issue a FinCEN ID to any person, individual or reporting company that submit to BOI. The FinCEN ID must be used when updating the reporting company's BOI and is exclusive to that individual or reporting company. And there will not be more than one ID to same person. So very important to safeguard information related to FinCEN ID. Penalties for non-compliance. Willfully provide or attempt to provide false or fraudulent BOI, including the false or fraudulent identifying photograph or document to FinCEN, subject to penalty. Willfully fail to report complete or updated BOI to FinCEN, it is also subject to penalty. Subject to civil fines of no more than $500 for each day the violation continues, and may be fined up to $10,000 and or imprisoned for up to 2 years. So those are the penalties for the non-compliance.
Thank you so much, everyone.
Thank you so much, Maunika and Jay, for that wonderful presentation. I do have so many questions. Well, I have a few questions. That was great information. I appreciate you guys covering all of that in detail. Do you want to add anything, Jay, or can we get started with questions?
No, you can start questions.
Wonderful. So why does FinCEN want all of this information? Can you touch on that for us a little bit?
So very few US states or territories require to companies to disclose information about their beneficial owners, the individuals who own the control companies. This lack of transparency allows criminal, corrupt officials, and other bad actors to hide their identities and launder illicit funds through the United States using shell and front companies. By collecting beneficial ownership information and sharing it with law enforcement, financial institutions, and other authorized user. FinCEN is making harder for bad actors to hide or benefit from their ill-gotten gains. Companies that report beneficial ownership information will be contribute to this important goal.
Thank you for that information. So let's say, for example, I've incorporated a company in November 2013. Shall I have to report to the BOI, and what's the deadline for this?
Yes, all the entities incorporated in the United States are required to file the BOI subject to the exempt list. If the entities is within the exempt list of 23, then they don't have to report. But otherwise, all the entities has to report. And for entities that has been incorporated in November 2020, November 2013, the deadline to report is January 1st, 2025.
So shall I have to file BOIR every year? Can you touch on that?
Answer is no. If any changes happen, like change of ownership, officers, address, you need to report within 30 days of the change made. Otherwise, you don't need to file every year.
That's great information. Thank you. And how will I report my company's beneficial ownership information?
If you are required to report your company's beneficial ownership information to FinCEN, you will do so electronically through a secure filing system available via FinCEN BOI e-filing website, boifiling.fincen.gov. So there you can just find the link and you can file from there.
Oh, wonderful. Thank you for that information. And who can file a BOI report on behalf of a reporting company, and what information will be collected on file?
Anyone whom the reporting company authorizes to act on its behalf, such as an employee, owner, or third-party service provider, may file the BOI report on the reporting company's behalf. And when submitting the BOI report, individuals filers should be prepared to provide basic contact information about themselves, including their names and email ID, email address, and phone numbers.
Thank you, Jay. That's really good to know. So is a member of a reporting company's board of directors always a beneficial owner of the reporting company? Do you have some information on that?
Answer is no. A beneficial owner of a company is any individual who directly or indirectly exercises substantial control over a reporting company or who owns or control at least 25% of the ownership interest of a reporting company. Whether a particular director meets any of these criteria is a question that the reporting company must consider on a director by director basis.
Wow, that's really good to know. Thank you for sharing that information with us. Now, regarding a reporting company's address, can a reporting company report a PO box as its current address? Is that allowed?
No, the reporting company's address must be the US street address and it cannot be the PO box.
Thank you, Jay. Just a few more questions for you guys. Should an initial BOI report include historical beneficial owners of a reporting company or only beneficial owners as of the time of filing?
Yeah, so the initial BOI report should only include the beneficial owners as of the time of the filing. So whatever is the latest, that has to be filed. So historical data has not been required. Reporting companies should notify FinCEN any changes of beneficial owners or related BOI through the updated reports once initially filed.
That's really good to know. Thank you for covering that for us, Jay. And is there a penalty for not filing BOIR? And if so, what is that penalty?
So, as we mentioned earlier, right, a person who willfully violates the BOI reporting requirements may be subject to civil penalties up to $500 each day that the violation continue. That person may also be subject to criminal penalties of up to 2 years imprisonment and the fine up to $10,000. So it's such a big penalty.
Wow, that is a big penalty. Thank you for sharing that information with us. We definitely don't want to get that penalty. So if you guys have questions about this, please reach out to our accountants. We're happy to help you out. You can send us an email at info@chug.com anytime. Okay, last question for you guys. I know I'm taking up a lot of your time and I appreciate you guys answering all of these questions. So what are the two types of beneficial ownership? Can you cover that for us?
Yeah, sure. So two types means a beneficial owner is considered anyone within stake of 25% or more in a legal entity or corporation. And the second is beneficial owner can also be considered anyone with a significant role in the management or direction of those entities or any trust that own 25% more than an entity. So whether like if a person does not have a 25% interest of partnership but is a control of the management or direction that entity, that is also called the beneficial ownership.
Thank you so much for that information, Maunika and Jay. I appreciate you guys sharing your time and insight with us. This does bring us to the end of our conversation. Thank you everyone so much for joining us today. To stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. And if this video was helpful, please make sure to give it a like. If you have any questions or suggestions, please feel free to send us an email at info@chug.com. And make sure to join us back here next week for more pressing questions that truly matter to you and your business. Until next time, stay safe and take care. Thank you, everyone.